Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Before Mr. Hivner calls the case, just a couple of things. I understand I'm in Knoxville, so our weather is vastly different from your all's right now. But if we should have it, if that should lead, or we for any other reason have any technology problems, we'll just take a pause and work through it. We don't anticipate any, but if we should, just take a deep breath and we'll work through it. Mr. Hivner, call the case, please.
At Last Inc., doing business as Blackwatch Investigation and Mitigation versus Terry Glen Buckley et al.
We'll hear from the appellant.
Good morning, Your Honors. May it please the court, Billy Ryan from the Memphis-Shelby County Bar, and I am reserved 3 minutes today.
Yes, sir.
Your Honors, this case comes to you on a decision from the Shelby County Court. Chancellor Jenkins, standard of review you're familiar with under Tennessee Rule of Appellate Procedure 13D, de novo, with the presumption of correctness unless the preponderance of the evidence establishes otherwise. And of course, any legal conclusions are reviewed de novo. Principally, we think the trial court erred in a number of reasons in awarding.
Counsel?
Yes, Your Honor.
Wait a second. I'm sorry, Mr. Hivner, the clock has gone back to 15 minutes. Now we're back. Okay, go ahead,
okay.
Mr. Ryan.
Principally, we think that the trial court erred in awarding attorney's fees for a number of reasons. Procedurally, this is just, it's before you on a really unique set of facts and circumstances. One, we think that there's a real question that whether the trial court even had jurisdiction to award attorney's fees after the non-suit order had been entered. As you may recall from reading the briefs, procedurally, a temporary injunction hearing was held. A temporary injunction was ordered in part. Thereafter, before the case was decided on the merits, a motion for attorney's fees was filed. We argued that it was premature to decide attorney's fees before a merits decision was rendered. Rather than going for a merits decision in any way, shape, or form, the plaintiff non-suited the case. That non-suit occurred on November 22nd, 2019. The court, in its non-suit order, did say it was reserving the ruling on the request for attorney's fees and costs. We challenged the trial court at the attorney's fees hearing a couple of weeks later. We challenged the trial court, basically saying, Your Honor, there is no case or controversy at this point after the non-suit, and that you've lost the authority to act and to award attorney's fees. If they revive the case and a merits decision is rendered, you may do so. Chancellor Jenkins obviously disagreed with us, but we think that there's a real question about whether he erred in deciding the motion for attorney's fees just based on a lack of jurisdiction after the non-suit had been entered. Now, I will concede.
Counsel, let me ask you a question, please. Isn't there some precedent out there that allows the court to do exactly what it did? Aren't there some other cases that have allowed the court to rule on attorney's fees issues after the case had been dismissed or non-suited, so long as the request had been filed previously?
It's yes, but it's always been the prototypical situation is where the plaintiff non-suit and the defendant moves for attorney's fees for a number of reasons. One, because there was a pending motion to compel or a pending motion for sanctions. Rule 54 gives the defendant the right to move for fees and costs after a non-suit is entered. This is a unique situation. I was unable to find any Tennessee court case where the plaintiff non-suited, but somehow reserved the right to seek fees after the non-suit had been entered. I think there's a real question, Your Honor. It's a novel situation. I wasn't able to find anything directly on point going for or against us, but we do think that there are serious jurisdictional issues that need to be considered. And frankly, it's above my pay grade. I think it's just a unique set of facts. We, of course, take the position that once the non-suit was entered, no case or controversy existed, and thus the trial court lacked jurisdiction at that point. There are other reasons. Of course, we think the trial court erred. First and foremost, if there had been no temporary injunction entered, there would have been no basis at all for any award of attorney's fees, much less a penny. We think that the trial court got most of Tennessee non-compete law right, but erred in one specific discrete instance. It was almost as if the court was almost across the finish line and then suddenly took a hard left and ran off the track. And by that, I mean specifically, the court erred in finding that a special relationship was formed by Glen Buckley with these Jackson area attorneys after he went to work for Blackwatch. And that's just not true. The Vantage Technology case is a leading case for us who do non-compete cases across Tennessee. And it's a leading case that actually discusses what a special relationship is. We all know that ordinary competition is good. Only unfair competition can be restrained. It doesn't matter if somebody signs a non-compete. Tennessee case law is very clear. Just because you sign a non-compete doesn't mean it's enforceable. The burden's always on the employer to establish a protectable business interest. Here, the trial court found that there was no confidential information or specialized training, so it only could default to the existence of a special customer relationship. And Vantage teaches us that the quintessential situation, I go to work for Judge Stafford. Through the course of my employment with Judge Stafford, I meet customers. I have repeated contacts with customers. I then go leave Judge Stafford. I go to work for Judge McGee, and I try to flip all that business and all those customers to Judge McGee's business. That's the quintessential situation. That's where we would all understand why a non-compete could be enforced in that situation. There, I'd be trying to piggyback on Judge Stafford's goodwill and attempting to flip the business to Judge McGee. The opposite was true here. Buckley knew all these Jackson area attorneys very well for many years in a professional manner, not just a personal manner, in a professional manner, as he was in law enforcement. They were in the criminal defense bar. Long professional associations, which the court acknowledged. The court also acknowledged that these attorneys had never done business with Blackwatch before Buckley became employed with Blackwatch. The court acknowledged that it was undisputed, and the plaintiff conceded that they only did business. These attorneys only did business with Blackwatch because Buckley was hired by Blackwatch. It was also conceded that they stopped doing business when Buckley left. Why? Because it was only because of their relationship with Buckley that pre-existed Blackwatch that caused them to do business with Blackwatch in the first place. So where the court really erred was it had nothing to do with Blackwatch's goodwill that they ever did business with these attorneys. It was Buckley's professional goodwill and close pre-existing relationships that brought this business to Blackwatch in the first instance. Interestingly, the trial court said, and you'll see in its order, I think it's paragraph 15 of the court's order, the trial court said that it was, it's page 173 of the record, technical record. That's probably the easier site. The trial court found that Blackwatch hired Buckley in part because of his pre-existing contacts. I can tell you, and you don't have to take my word for it because you'll dig into the case law yourself, but every practitioner out there that operates in this space operates under the presumption that if you bring a book of business to the employer, you're going to be able to leave with that book of business, absent some really unique circumstances. This is not the prototypical situation, again, where I get hired by a company and through that employment, I develop the business after I get hired. Here, the relationships were developed beforehand. So it's not a situation in any way, shape, or form where Mr. Buckley was piggybacking or hijacking Blackwatch.
Let me ask you a question, Mr. Wright. The relationship that you're talking about, does it matter in your analysis that as the facts as I understand it, your client had a relationship with the attorneys, but it was not a business relationship. It was, in fact, a professional relationship because he was in law enforcement. But after he retired, he didn't have a business relationship with them until he went to Blackwatch, did he?
That's correct.
Am I missing something there?
I would disagree. I think semantics are important. They did have a business and professional relationship, but they had never exchanged money. He had never done investigative services for money with these attorneys. Now, it doesn't make a difference in the.
Let me ask you a question. Let me ask you one more question, then you can go where you want to go with this. But so I want to get my facts straight. He retired from law enforcement.
Yes.
And then he went to work with Blackwatch.
Yes.
Before he began his other career. Would that be correct?
Yes. Yes. Yes.
Okay.
Yeah.
All right. Now
that's
go ahead
right.
and say what you.
And again, Blackwatch knew what they were getting, a seasoned investigator who had contacts, and they were going to do business with these attorneys because of Buckley, not because they hired Buckley and they trained him and they gave him, a set of skills that allowed him to procure this business. Buckley brought this business to Blackwatch in the first instance. And the reason why it doesn't make a difference that he had never actually received money from these attorneys is, if you look at our opening brief, pages 18 and 19, we cite cases from around the country. Tennessee just has never addressed this issue, frankly, but we think the Vantage technology case instructs this result and demands this result. And that is, if you have contacts that pre-exist and you have relationships that pre-exist, you are not piggybacking on, in this instance, Blackwatch's goodwill at all. In fact, it's Blackwatch that's piggybacking on your goodwill. And the cases from around the country almost uniformly state pretty clearly that if you're not capitalizing on the employer's goodwill and it's the other way around, then the employer can't establish a protectable business interest to justify the enforcement of the non-compete. Now, I do want to say, I'll use my final minute. The Cab versus Ingram case, 1984, Tennessee Supreme Court cautioned against this very scenario. Buckley had two choices. He could either lay down and not fight and allow Blackwatch to get away with an indisputably overly broad non-compete agreement, or he could fight. Guess what? He fought. The court gave us 80% of what we wanted. They struck the geographical scope. They struck the court struck the temporal scope. He found that it was overly broad with respect to the clients. This was a win by any estimation. This was a win for Buckley. Yet the court still, in a one-way attorney's fee provision, Buckley had no ability to get attorney's fees in this case. The court still awarded $20,000 in attorney's fees. And Cab versus Ingram says that this is the kind of situation where it should not be enforced. The attorney's fee.
Mr. Run.
Yes,
Mr. Run. But the trial court also found that your client breached the agreement, correct?
No, Your Honor. It was a temporary injunction hearing. The court found that it was a probability that there would be a finding in favor. A temporary injunction standard is a lot different than a merits decision. They never, and I'll wrap up because I see my time's concluded, but they never moved under Rule 60.
Take your time to answer Judge McGee's question.
Yeah, very importantly, we say in our opening brief, they never moved to consolidate the matter on the merits. Rule 65.04 subsection 7 allows a plaintiff in this situation to consolidate a temporary injunction with a decision on the merits. So what the court did, if you look at the order, it just applied the temporary injunction standard, which said there was a probability, but there was no finding of a breach. That's the whole. That's another reason why the attorney fee award was in error. Because if you look at the plain language of the attorney fee provision, it contemplates an express finding of a breach. At the very least, it's ambiguous and should be construed against the drafter. Here, they could have easily asked to consolidate the case on the merits under Rule 65. They did not. Thus, that was the whole thing. That was the reason why the court found procedurally that a final order of some kind had to be entered before it could even reach the attorney fee award. And they chose this sort of a goofy way of doing it by non-suiting the case rather than moving under Rule 65 to consolidate the case on the merits. I've never seen a situation like this, but there was no breach.
All right, you have your time for rebuttal. We'll hear from the appellee.
May it please the court. My name is Ramon Damas. I represent Blackwatch Investigations. And I'd like to address Judge Stafford's question regarding whether the existence of a business relationship matters. And it does. It does matter if there was a business relationship or not. The facts of this case are clear. Mr. Buckley had never worked as a private investigator, had never had any clients per se before working for Blackwatch. In fact, if I'm recalling correctly, I believe that Mr. Buckley, in fact, left the Jackson Police Department law enforcement once he had accepted employment with Blackwatch. He never had any sort of exchange of services with specifically Attorney Donahoe and Attorney Byrd. And if it wasn't for Blackwatch's employment of Mr. Buckley, if it wasn't for their goodwill and reputation, Attorney Donahoe, Attorney Byrd would have never had the ability to hire Mr. Buckley before his employment. Mr. Buckley was not licensed as a private investigator, had never done the type of work that a private investigator does for a criminal defense attorney. And now I understand that at trial, they had there was conflicting testimony as to whether the services provided by a private investigator are essentially the same as that of a law enforcement officer. But without question, Mr. Buckley had never worked as a private investigator for any of these attorneys. And focusing on the prior relationship or whether or not a business relationship existed with these two attorneys, ignoring the fact that the non-compete was enforced in relation to 4 other attorneys. There's Attorney Smith, Attorney Simmons, Attorney Owens, and Attorney Hughes, saying that, oh, Mr. Buckley had a prior relationship, professional, business, or otherwise, with these 2 attorneys does not invalidate the non-compete in relation to these 4 other attorneys that were clients of Blackwatch at the time that Mr. Buckley resigned from his position, and who he admitted in his affidavits that he was performing services for after he had left for Blackwatch. This is the quintessential example of why we have non-competes. Mr. Buckley went into this employment not knowing the business aspect or what it takes to be a private investigator, or how to run a business with a private investigation company. Blackwatch invests significant amounts of money in obtaining technology so they can perform cell phone forensics. They market him in the area as their leading investigator, their leading face of the company, by making him, paying him to go to tactile organizational meetings, to teach CLEs on their behalf. And he, in this aspect, in the Jackson community, becomes the face of Blackwatch. The fact that it was, if not for the goodwill and the reputation of Blackwatch, is evident by the fact that when Buckley decides to leave, one of his solutions, one of his ways to get around the non-compete is to ask Blackwatch to allow him to open up a franchise office. He says, hey, let me continue using your face. Let me continue using your reputation to open up my business here. And to simply say that the lack of a business relationship doesn't matter is just unequivocally wrong.
Counsel, let me redirect you here. If you had not taken a non-suit, what was left? What was going to happen?
If we have not taken a non-suit, Your Honor, what would have happened is that a trial on the merits would have had to happen. Needless litigation would have to.
Okay, and what if you'd lost?
I'm sorry?
And what if you had lost on the trial on the merits? Would you have gotten an award of attorney fees?
I believe so, Your Honor.
Even if you'd lost? Even if at the trial on the merits, you lost. We don't know because it never happened. But even if you had a trial on the merits and you lost, is it your position you still would have been awarded attorney fees?
No, Your Honor. I believe that as long as the trial court found that the agreement was enforceable, we would have been granted the awarding of attorney fees. And that's exactly what happened.
Well, I mean, the trial court found that you were entitled to a temporary injunction. That's not the same as the final judgment, is it?
No, Your Honor. But in finding that the temporary injunction was granted, and in fact, in the way the trial court granted the temporary injunction, he said that I believe that the temporary injunction was only going to last for 6 months, and there's no geographical restrictions. By the time that this case would have gone to trial, that enforcement, that non-compete had already been satisfied. I believe the hearings was had in the beginning of the year. By the end of the year, Mr. Buckley had complied with the temporary injunction's restrictions, and Blackwatch was satisfied. Blackwatch, the only thing they ever were worried about, the only thing they ever cared about, essentially in all of this, was that they'd be given the opportunity to prove to their clients that they can still provide the same level of service, the same level of work that they had been providing prior to Mr. Buckley's resignation.
Okay, I'm sorry, counsel. I'm going to interrupt you again. My question is, how are you entitled to an award of attorney fees under the contract when there was no final determination that you win under the contract?
Under the contract, Your Honor, if my record site is correct, on page 71 of volume 1 of the technical record, it lays out the plain language of the contract. In it says that we're allowed to pursue attorney fees for any expenses incurred in finding that making sure the contract, the non-compete, is enforced. We believe that it was enforced. The moment the trial court granted a temporary injunction and put these restrictions on Mr. Buckley, and when Mr. Buckley complied with those restrictions and satisfied the time period for which the non-compete was valid for, essentially enforced. And once it was enforced, we believe we're entitled to the attorney fees that it was spent in incurring and securing that enforcement of the non-compete. It's important to note that Mr. Buckley, opposing counsel, said, "Oh, he was only left with 2 options. He was either left to lay over or fight." He didn't fight. He decided to just go ahead and do whatever he wanted. He had the ability to get a declaratory judgment to figure out, hey, is this non-compete even enforceable? But he didn't do that. He simply stated, hey, I'm going to do what I want. I'm going to go ahead and start this company and flagrantly disregard the agreement that I had signed to. That is unfair competition to Blackwatch. Blackwatch went out either way. They say, hey, stop what you're doing. Don't do this. We have a valid non-compete. And they disregarded that. They said, no, we're not going to abide by that. We're not even going to see if we should even abide by that. We're just going to do whatever we want. It's important to note that even an important aspect of granting of awarding fees is to determine who is the prevailing party in all of this. And that is without doubt Blackwatch. In console waste systems, this court found that the prevailing party is defined as the party who benefits from the alteration of the legal relationship between the parties when a party's behavior is modified by the court. There's no question that Mr. Buckley's behavior was modified to materially alter the legal relationship between the parties the better Blackwatch. Changing the length of the non-compete and taking away the geographical restrictions still modified Buckley's behavior. It said, hey, for 6 months, you can't compete with these 6 clients. You can't perform services for these 6 clients. You have to allow Blackwatch an opportunity to win them back, so to say. That is materially modifying his behavior to the benefit of Blackwatch. And when there is a prevailing party, according to Otter's Chicken Tenders, the prevailing party is a significant factor in determining whether or not to award attorney fees. At the trial level, the court didn't say, hey, when we filed the motion for attorney fees, it said, hey, this is well taken. I just want to wait till the end. There's other issues that still need to be resolved. Once those get taken up, we'll readdress on the issue of attorney fees. We took a strategic decision in that moment. Hey, we already got what we wanted. There's no need to continue litigation, continue billing and getting higher attorney fees if we're already satisfied with the court's decisions and we feel that the non-compete has been enforced to our favor. And that is why the non-suit was taken. In terms of going back to whether or not this non-compete, this temporary injunction should have ever been granted, the court went through many factors in determining that Blackwatch did have a protectable business interest. And it was for that very factor, for that very reason, that he enforced the temporary injunction. And when it comes to a trial court's decision as to granting or dissolving a temporary injunction, that's within their sole discretion. And this court has found that in those types of cases, we review those decisions based on an abuse of discretion standard. And according to State versus Scott, the Tennessee Supreme Court says that an abuse of discretion standard, a ruling will still be upheld so long as reasonable minds can disagree as to that decision. If this court agrees to that decision, just because this court might disagree.
Let me ask you a question, counsel. Opposing counsel has not yet addressed this, but I assume it's going to come in rebuttal, and that is the amount of attorney's fees. Assuming we get to that point, whether the amount of attorney's fees is properly awardable, did the trial court do the proper analysis to determine if this fee amount was correct?
Yes, Your Honor. I believe in its ruling awarding attorney fees, and went through a bunch of different factors when deciding whether or not the amount was reasonable. It looked at the going rate for attorneys in this type of work in the area. It found that it was in alignment with the going rate in the area. It found that the matter was hotly contested, so it wasn't just like stacking of hours or whatnot. It was a temporary injunction hearing that lasted 2 days. I believe they had one hearing initially, and then they rescheduled for the second part a few weeks later. So it was a hotly contested matter that had multiple witnesses that testified and multiple arguments that was done before the court. And when the court looked at these factors, and on top of the factor that Blackwatch was the prevailing party, it reasoned that the amount was reasonable for what had occurred at the trial level. And with that, Your Honors, I concede the remaining of my time, and I thank you this morning.
Thank you. We'll hear from the appellant in rebuttal.
A number of quick points.
Mr. Ron.
Yes, Your Honor.
Before you get started, I questioned you earlier about the court's findings as to a breach, and you said that the court did not find that your client had breached this agreement. And I'm reading from page 13 of the order, which specifically says Mr. Buckley has breached the agreement. But you're saying the court did not find that?
No, that's what the court said, but breach in the sense of a final, again, the temporary injunction standard is just a probability on the a probability of success on the merits. It's not equivalent with a actual finding on the merits. And that's the reason why every plaintiff that I've ever encountered who's seeking to enforce will actually move for a consolidation on the merits in this kind of a situation. It was strange that they didn't do so, but that was,
you had a 2-day hearing on this, correct?
Yes, Your Honor, temporary injunction hearing.
A 2-day hearing with several witnesses.
Right. It was not a trial on the merits, however.
I understand that, Mr. Ryan.
Yeah.
However, I'm just asking you what the court found as a
Yes,
result of all the proof that you put on.
Right. And what the trial court found was that there was a probability of success on the merits under Rule 65 of the temporary injunction standard. It was not a finding on the merits. That is, there's no question about that. The trial court also said at page 18 of its order in 185 in the technical record, it said, it is undisputed that it is only because of defendant Buckley that plaintiff did any business with Jackson area attorneys such as Donahoe, Byrd, and others. These other attorneys had never done business with Blackwatch, and they would have only done business with Blackwatch because of Buckley. So that needs to, the record needs to be set straight there. Also, Vantage Technology does not speak in terms of a special business customer relationship. It's a special customer relationship. And so the law in Tennessee is more broad than what opposing counsel would posit, that there had to be some kind of money exchange. It's just not the case, nor do the cases around the country that have addressed this issue have any of those been so limited. Now to Judge Stafford's last point, there is no basis for the Court of Appeals to do a meaningful appellate review because the court did not go through the RPC 1.5 factors in making the attorney's fee award. There was no thoughtful consideration. The court basically said, okay, they've asked for $27,000. I'm going to award them $20,000. And there was no discussion with respect to the results obtained by the parties. That's probably the biggest factor that the court ignored. And as Wright versus Wright instructs, for you guys, for the court to have a meaningfully basis to review, there's got to be an explanation and a discussion of the factors. And that wasn't done. Another reason why the court's order should be struck. Thank you very much, Your Honors.
Thanks to counsel for both sides. We appreciate your oral argument and your briefs in this matter. Mr. Hivner, if you'll recess court until, I believe it's 11 o'clock for the next case.
This honorable court is now in recess until 11 a.m.
Thank you.
Thank you. Stay warm and safe.
Thank you. Bye-bye.
Thank you. Bye-bye.